as such by penal laws. It must be understood as criminal acts in the more general sense. Paditis cites as an example the massacres organized by the Turkish authorities. Technically, these acts did not come within the provisions of the penal code. Some people thought, and he agreed, that it was necessary to include among the prosecutions of an international character in respect to acts which violated what might be called the law of humanity. The Romanian delegate, Rosenthal, observed that while Armenia had not been recognized as a power, it was not possible to leave any doubt surrounding the crimes committed in Armenia. And in fact, in this commission's report, there is a list of summary charges. And among the charges that is listed here are the massacre of Armenians by Turks systematically organized with German complicity. More than 200,000 victims assassinated, burned, or drowned in Lake Avan, the Euphrates, and the Black Sea. This charge listed by the Greeks on behalf of their Armenian delegation. How are you going to move forward then, once you make this charge? Well, this 1919 commission says, we're going to come up with a framework. We propose that we will try violations not for just the violations of the laws of war, but for the laws of humanity, 1. And 2, these violations will be tried not by individual military tribunals, but by an international high tribunal. And 3, these charges can extend to the heads of state. Look at these 3 things. Clearly, the principles that many Anglophone and especially US scholars identified with the US role at Nuremberg were already in sight in 1919. So why didn't it happen? Well, one state stood in stubborn opposition to this program. Yep, it's the United States. The US position was complicated, just as the British response to the Armenian genocide note had been complicated. It resulted in no small part from a distinctive US view on international law. Both the US delegates, Secretary of State Robert Lansing and the legal scholar James Brown Scott, had written before the war of their opposition to using international penal law as an instrument. Moreover, the US delegates, and Secretary Lansing in particular, were suspicious of the European colleagues. Lansing in particular was terrified that Europe was about to be awash in revolution, and the only successful bulwark against revolution was state sovereignty. And anything which threatened state sovereignty had to be opposed. The lead British delegate, Ernest Pollock, the Solicitor General for England and Wales, tried to convince the US delegation. He addresses Lansing directly. "We believe, for the peace of the world, it is right that we should bring to trial those who are responsible for such unconscionable breaches of the principles of humanity which have been committed. That is, I believe, the root difference between your views, Mr. Lansing, and mine. But it is one which the British Empire intends to insist upon." Lansing was not convinced. He declared the US delegation's sole opposition to the Commission's unanimous, except for the US opposition, consensus on this issue. Lansing: "We've been laboring here for 6 weeks. Everybody has endeavored to find a formula that would harmonize irreconcilable differences. We have failed. Frankly, we have failed. The United States went as far as it could without surrendering what it considered fundamental principles. It is not a failure from a lack of desire or a lack of effort. It is simply that our views, that is the US views versus everybody else's, no more mingle than oil and water." And as a result of the US delegation's solitary opposition, all articles in the peace treaties that are composed make no mention to violations of the laws of humanity. The US delegation insists that you can only try people for violations of the laws of war. That is the impact of this commission report. It doesn't end there, though. There are 2 concrete consequences of this majority opinion report from which the US stands in isolated opposition. The first is all treaties at the Paris Peace Conference are modeled on the Treaty of Versailles for Germany. None of these mention crimes against humanity, only mention violations of the laws of war. There's one exception, and that's the Treaty of Sèvres with the Ottoman Empire, which is not implemented. But beyond the articles which match the articles of the Treaty of Versailles for Germany, there's an additional article, Article 230 for the Treaty of Sèvres. which reads, "The Turkish government undertakes to hand over to the Allied powers the persons responsible for the massacres committed during the continuance of the state of war on the territory which formed part of the Turkish Empire on 1 August 1914. In other words, the Turkish state commits itself to surrendering officials who had been responsible for murdering Ottoman subjects within the boundaries of the Ottoman Empire when the war began. The second consequence is the historical precedent of this majority opinion report. We're now in 1945. The men who formed the 1945 and post-1945 legal order saw the foundations of their work in 3 documents. One, the Martens Declaration, as enshrined in the Fourth Hague Convention of 1907. Second, the Allied Note of May 24, 1915. And third, that majority report of 1919. In the summer of 1945, the Allies convened in London the 4 power negotiations to establish the mechanisms and framework for the Nuremberg trial. In 1945, the US delegation repudiates the stand that its prior delegation in 1919 had taken. That is, it will now accept that there will be an international high tribunal, it will try heads of state, and that you can try people for violations beyond the laws of war. But the US position at London initially was focused only on Germany committing aggressive war. Chief Justice Jackson was fixated on only trying Germany for what it had done in committing aggressive war. He argues that, I quote, this is a shocking statement, "It has been a general principle of foreign policy of our government from time immemorial that the internal affairs of another government are ordinarily not our business. That is to say, the way Germany treats its inhabitants or any other country treats its inhabitants is not our affair, any more than it is the affair of some other government to interpose itself in our problems. The reason that this program of extermination of the Jews and destruction of the rights of minorities becomes an international concern is this: it was part of a plan for making an illegal war." So what Jackson is saying is, I only want to be concerned about what Germany did to Jews and its Jewish population insofar as it's related to Germany's conduct of aggressive war. This shocks some of the other delegates, including the French delegate. The French delegate, André Gros, protests. "We appear as wanting to prosecute because of racial or religious treatments only because they were connected with the war, Mr. Jackson. I know you express this very clearly, that we are in fact prosecuting those crimes only for that reason." But he continues. "But for the last century," Gros says, "there have been many interventions for humanitarian reasons. All countries have interfered in the affairs of other countries to defend minorities who are being persecuted." Gros here clearly has in mind complementing the more clearly defined laws and customs of war with a 19th century precedent of humanitarian intervention. It is in result of these dialogues that the London conference comes up with a definition that will undergird the Nuremberg trials. You will try Germany and German detainees for crimes of violations of the laws of war, crimes against the peace, and crimes against humanity. Conclusion. The Allied Note of May 24, 1915 built upon an existing 19th century precedent, but it introduces a new phrase, crimes against humanity. I have tried to situate the story of the emergence and development of this term within an expanded chronological perspective and several arcs. The first is the significance of the precedent of humanitarian intervention by the great powers in the 19th century.